Good afternoon. Welcome to this webinar on the implications of Brexit on residence rights and social security. My name is Anthony Valcke, and I'm one of the experts for Your Europe Advice. So the purpose of this webinar today is to look at some of the implications which Brexit may have for citizens' residence rights and social security rights going ahead into the future when the UK eventually withdraws from the European Union. In terms of residence rights, we can see that Brexit has definitely had an impact on the kinds and numbers of inquiries which Your Europe Advice is receiving. Some of the typical inquiries that we are receiving from citizens, both UK citizens living in other European countries and EU citizens living in the UK, is what will the immediate effect be of the referendum on residence rights in the UK? And also in the EU. And of course, at this stage, although we have had the referendum, the United Kingdom is still a member of the European Union. So European law continues to apply as it has done since the UK has joined the EEC back in 1973. So there is no immediate effect at the present of the referendum on the ability of European citizens to exercise residence rights in accordance with European law in member states other than their state of nationality. So the referendum has had no direct impact at the moment on residence rights of EU citizens in the UK and likewise UK citizens residing in other member states. Another question that we get is, can EU citizenship be retained after the UK withdraws from the EU? And unfortunately, the answer to that is no, because European citizenship is conditional upon holding the nationality of a member state. And if the UK withdraws from the European Union, it will no longer be a member state, and therefore British citizens will no longer enjoy the status of European citizen. Another question we get is, can British citizens challenge the referendum result within the context of the European legal framework? And that means in practice whether it's possible for British citizens to challenge the referendum result before the European institutions. And again, the simple answer to that is no. The EU does not have the power to intervene in internal constitutional affairs. The referendum result was held as a matter of the UK's own national law, and the European institutions have no ability to challenge the referendum result. So the referendum result, it's up to the British government to decide what to do with the referendum, and it's up to the UK government to trigger Article 50 in line with its constitutional traditions. In terms of other more practical questions that we're getting also questions such as, should European citizens apply for permanent residence in the UK? Should EU citizens apply for naturalization as British citizens? Or what could the UK nationals at present do to safeguard their rights in other member states? So these are some of the questions that we're now going to look in more detail and identify some best practices. So at the moment, although EU law and residence rights continue to be governed by the same legal instrument, namely Directive 2004-38 on residence rights, and although in the UK it is not obligatory for EU citizens to apply for residence documentation, we would advise all European citizens and their family members to indeed apply for residence documentation, whether or not they have obtained permanent residence. We can anticipate that if the UK sticks to its bargaining position that they wish to reintroduce immigration controls following the UK's withdrawal from the EU, then we can anticipate that it is likely that EU citizens will be required, will be obliged to hold some kind of residence documentation once the UK has left the EU. So at the moment, it should be, we would recommend that all EU citizens apply for some kind of residence documentation, be it a registration certificate if they have not lived in the UK for over 5 years, or if they have lived in the UK for over 5 years, they should apply for a permanent residence card. Permanent residence document, and their family members should also apply for a residence card or a permanent residence card, as the case may be. Now, the UK has now made it possible for EU citizens to apply online, be it for a registration certificate or a permanent residence document. But unfortunately, non-EU family members still have to apply by post to the Home Office. On the slides which accompany this presentation, you'll be able to find some links to the online registration websites which have been set up by the Home Office. There is one specifically for EU citizens to apply for registration certificates. There is one to apply for permanent residence documentation. We also attach a video guide which has been produced by Colin Yeo at our Friends of the Free Movement blog, and a link to that explanatory video is also included in the slides. And as I said, for non-EU family members, it is not possible to apply online, and they still have to apply by post to the Home Office. Another question, of course, that we get is what is going to happen should there be no reciprocal deal following Brexit. So in the event that there is no special agreement negotiated by the UK and the EU, the situation would be that EU nationals would be covered by the UK immigration rules. The UK may decide to create special rules for EU citizens, but if it does not, then the following rules would apply for EU nationals living in the UK following the UK's withdrawal from the EU. All EU citizens who would want to work would need to get a work permit. The family members would be subject to the family reunion rules contained in the UK immigration rules, which means that EU citizens would have to demonstrate, if they wanted to bring family members over to the UK, they would have to demonstrate that they have a specific income, which currently is £18,000 per year, which rises if there are children as well. There are specific rules for ascendants and parents. For example, an ascendant must be aged usually over 65. There are specific rules for parents of British children. And these rules, if they were to be applied to EU nationals by the UK, in the absence of more favourable rules, then the full UK immigration rules would apply. It should be noted that there is no general leave to remain for self-sufficient persons, unlike the current UK rules that give effect to the EU directive on residence rights. And there are also specific tighter, more restrictive conditions for students who should bear in mind that they would not necessarily have the right to remain in the UK upon completion of their studies. It is also a general requirement before the UK's permanent residence, or what is called indefinite leave to remain, before that is acquired, before citizens, nationals of other member states, nationals of other countries get to obtain indefinite leave to remain after 5 years of residence. Before that, there is a general prohibition on the ability of non-nationals to access public funds. So again, if the UK was to move to a situation where it would apply the UK immigration rules in full, there would be no recourse to public funds allowed for EU citizens until they have acquired indefinite leave to remain. In addition, they would have to pay what is called the health care surcharge, which is a compulsory contribution towards the national health insurance costs. And that is currently £150 per year for students and £200 per year for others who are non-students. And they would have to show knowledge of English. So this is a general overview of what would happen in case there was no reciprocal deal and EU nationals would be covered by the UK immigration rules. We could see that in the absence of any specific, more favourable rules applied by the UK government, UK immigration rules would apply fully. But the UK government, of course, has indicated that it is willing to have a reciprocal deal whereby the right of EU citizens in the UK would be protected, provided the right of UK nationals in other member states would be protected too. So that would be something that would be negotiated by the British government as part of its Article 50 negotiations once it has notified the EU of its intention to withdraw from the European Union. Another question we get from EU citizens living in the UK is, should they naturalise as British citizens if they've been living there over 5 years? And EU citizens should be very careful when considering whether to apply for naturalisation as British citizens, because if they were to acquire British citizenship, then they would no longer be considered EEA nationals as well, because the UK's rules that give effect to the Residence Rights Directive in the UK contain a special definition of who is an EEA national. And those regulations define an EEA national as meaning a national of an EEA state who is not also a British citizen. So therefore, if EU citizens were to acquire British citizenship as dual British EU nationals, they would no longer benefit from EU rights following naturalisation because of the way that EEA nationals are defined in the UK's regulations that give effect to Directive 2004/38. Therefore, if an EU citizen has family members residing in the UK, they should not apply for naturalisation until a year after the family member has obtained permanent residence in the UK, and therefore would themselves be able to apply for naturalisation as British citizens. Now, the issue, though, is given its uncertainty whether the UK's definition of an EEA national, excluding the benefit of the EU rules for dual British and EU citizens, that issue has been the subject of a pending case before the Court of Justice in Luxembourg, in the case C16516 Lunes. So the issue will eventually be examined by the Court of Justice, the EU Court of Justice in Luxembourg. So that's something to bear in mind, is that EU citizens should obtain legal advice as to whether it is appropriate for them to apply for naturalisation as British citizens, as this may impact upon their ability of their family members to continue residing in the UK with the benefit of EU rules. Now, that is we've looked at so far the position of EU citizens residing in the UK. Now, what about the situation of UK citizens residing in other member states? Of course, the same advice holds, that UK nationals who reside in other member states should ensure that they have residence documentation. Now, some member states, like Ireland, like France, do not oblige UK nationals to apply for residence documentation. And we would encourage UK citizens who do not currently hold residence documentation in those countries where, in other EU countries, to apply for them as soon as possible. Now, another question is, what would be the situation that we have received? Another question that we have received is, what would be the situation if there is no reciprocal deal following Brexit? Then in that situation, of course, UK nationals who live in other EU member states, if there is no reciprocal deal, if there's no specific transitional provisions that allows them to keep the benefit of EU rights, then those UK nationals who reside in other member states would be considered non-EU nationals, what are called third country nationals in EU legal jargon. And it should be pointed out that some of these UK nationals may be able to rely on Directive 2003/109 on long-term residence. And this directive, which the UK, Ireland, and Denmark have opted out of, this UK applies to the other 25 member states which do apply the directive. And this directive, specifically its Article 4, requires member states to grant long-term residence status to third country nationals who have resided legally and continuously within the territory of the member state for a period of 5 years prior to the submission of the relevant application. So in the event that there was no specific reciprocal deal between the UK and EU to protect acquired rights, then UK nationals who have been residing in other member states for over 5 years may be able to benefit from the long-term residence directive. But it should be pointed out that, firstly, studying is explicitly excluded by Article 3 of the directive. So unfortunately, UK nationals who have resided in other member states for during which time they have studied, that period of studying would not count towards the acquisition of long-term residence status. That is in the event that the long-term residence directive would be applied in accordance with how the Court of Justice has examined a similar situation under the residence directive. And specifically in joint cases 424 and 425 of 2010, Ziolkowski and Dzieja, this was a case that concerned Polish citizens living in Germany who had been living in Poland since before Poland became a member state. And the question that the Court of Justice had to look at is whether periods of residence acquired prior to Poland's accession to the EU could be counted for the purposes of acquiring permanent residence under the Citizens Directive. And the court said that that is only possible if the periods of residence which were completed before the accession of Poland to the EU, if those periods of residence met the conditions of the Citizens Directive, which meant that they had to be either working, or if they weren't working, they had to have sufficient resources not to be a burden on social assistance, and have comprehensive sickness insurance. If we apply that case, the principle of that case, to the situation of the long-term residence directive, then that would mean that the periods of residence completed, applying it by analogy, it would mean that periods of residence completed prior to the UK leaving the EU could be factored into for the purposes of acquiring long-term residence, but only if the conditions, if those periods of residence met the conditions of the long-term residence directive, which means in effect that in order to acquire long-term residence, a person would have to demonstrate that they were working or had sufficient resources not to be a burden on social assistance, and have comprehensive sickness insurance. But it would exclude, unfortunately, students who had been studying in another member state. So that is what would happen in the worst case scenario, in the event that the UK was to leave the EU without some kind of transitional or acquired rights protection been negotiated between the UK and the other member states. In the worst case scenario, then some UK nationals who live in other EU countries could claim the benefits of the long-term residence directive, but unfortunately, certain categories such as students would not necessarily be able to acquire long-term residence under that legal instrument. Now, before we turn to the issue of social security, I wanted to touch upon some recent developments in the UK that affect residence rights for EU citizens residing in the UK. One of the things that we've seen is that the last few days, the UK government has released its statistics on immigration. And we can see that there's been a substantial increase in applications by EU citizens residing in the UK for some kind of residence documentation. If we compare the number of applications that were made in the period July, August, September of 2016, over 56,000 applications were made in that quarter. And that represents a 250% increase compared to the same period in 2015, where between July and September of 2015, 22,000 applications were made. So we can see that the referendum result has had an effect on the number of applications that EU citizens are making in the UK. At present, when we look at current rates of refusal, the numbers of applications which are being refused or declared invalid by the UK Home Office stands at currently around 32% if we're looking at figures just for the first 9 months of this year. But if we look at the average roughly for the last few years, it stands around 40%, particularly if we look at the rate of refusal since 2012, which reached about 43%. Then it went down to about 40% in 2013, and 38% in 2014, and 37% in 2015. So roughly, the rates of applications are being refused at roughly and declared invalid at a rate of roughly 40% at the moment. In addition to these relatively high rates of refusal, and when we compare the rates of refusal between the UK and other member states, the UK has definitely got the highest rates of refusal for residence applications of any other member state that publishes statistics for refusal rates in the EU. Another thing that has taken place in the UK is that the UK has revised its immigration regulations, which will take effect in 2017. And under the new immigration European Economic Area regulations of 2016, there's been a few changes. One which will affect ongoing applications is that applications will in the future have to use the standard forms which are published by the Home Office. Otherwise, the application will be declared invalid. So depending on the situation, if it's EU citizens applying for a registration certificate in their capacity as workers, students, or self-sufficient persons, they will have to use Form EEA-QP. Family members will have to use Form EEA-FM, etc., etc. For permanent residents, it's Form EEA-PR. Also, the UK has now introduced a new possibility for the UK authorities to withdraw the benefit of residence rights for what is called misuse of right of residence. So this is not just this extends the ability then of the UK authorities to refuse residence documentation to those who they feel are misusing their right of residence. So it's not just abuse of right of residence. This is a new separate possibility, separate ground for refusal, which is misuse of a right of residence. The other thing to note, there's been quite a few changes, and we're currently digesting the effect of these changes. But some of the things that strike us as particularly glaring is that the possibility for expelling EU citizens on public interest grounds has been expanded. And that appears at first sight to be contrary to the protections given in the Citizens Directive in Directive 2004/38, because it vastly increases the powers of the UK authorities to be able to expel EU citizens and family members on public interest grounds. One example is that they will in the future be able to expel EU citizens for the purposes of maintaining public confidence in the UK's immigration system, which seems a very wide power indeed. Another development when it comes to the UK's rules which have implemented the Residence Directive is that the ability of extended family members, so those are family members caught by Article 3, Paragraph 2 of the Directive 2004/38, specifically unmarried partners and other dependents or members of the household, they no longer have a right of appeal following the changes to the immigration EA regulations, which will take effect in 2017. And that follows the upper tribunal's decision over the summer in Salah, which concerned an Albanian family member who was claiming the benefit as an extended family member, where the upper tribunal held that extended family members do not have a right of appeal under the immigration EA regulations, which give effect to the directive. That is a highly questionable ruling by the upper tribunal. As far as I know, the upper tribunal decision was not appealed further to the Court of Appeal. And as a result, the UK government has used this to incorporate and codify this ruling so that extended family members, other family members caught by Article 3, Paragraph 2 of the Citizen Directive, will no longer have a right of appeal against decision refusing them a right of residence in the UK, or an EEA family permit, which is a kind of visa to get them to the UK in the first place. Some worrying developments there. Some immigration practitioners believe that the UK is trying to test the waters by creating a blueprint that might serve as an indication of the future rules that might apply to EU citizens following the UK's withdrawal from the EU. And in terms of what the possible deal, if there was a deal between the UK and the EU, of course, that's highly speculative. But if we look at what the UK's demands, which have been made public, we can see that there's three broad so-called red lines, which apparently are what the UK government believes are non-negotiable in future negotiations once it has triggered Article 50. The first one is that the UK government is intent on imposing controls on EU migrants. And we've seen in the press reports from government ministers saying specifically that those controls would be placed on EU migrants who come to work in the UK, which seems to suggest that the UK is wanting to impose work permits on EU migrants who come to the UK, so that they will require them to either have a work permit or a firm offer of employment. And coupled with that, they want to restrict the ability of EU citizens who come to the UK to be able to benefit from the social welfare system for periods of 4 to 5 years following their admission to the UK. Also, one of the other non-negotiables, according to the press reports, is that the UK will refuse to be subjected to the jurisdiction of the Court of Justice. That, coupled with the desire to impose immigration controls, specifically on EU migrants who come to work to the UK, would seem to suggest that the UK is not inclined to accept free movement of citizens, of EU citizens to the UK, so that it will do away with the ability of EU citizens to enjoy free movement, which obviously means that the UK would not be able to be retain full membership of the single market as a member of the European Economic Area, because it is a requirement of that agreement that all states party to the EEA agreement sign up to the 4 freedoms. That is the freedom of movement of people, the free movement of goods, the free movement of services, and the free movement of capital. Those are undivisible freedoms. So if the UK was to impose controls on EU migrants, and specifically imposing work permit requirements, and also refuse compulsory jurisdiction of the Court of Justice or the EFTA Court, which is the court which applies the EEA agreement to Iceland, Norway, and Liechtenstein. In the event that is the UK's negotiation position, then the UK would not be able to remain a member of the single market. The other condition, although press reports recently seem to suggest a softening of that position, is that the UK does not want to contribute to the EU budget. But we've seen in the last few days reports from government ministers saying that they are open to negotiate that aspect. But there doesn't seem to be a softening of the position when it comes to controls on migration of EU citizens to the EU, to the UK, or to the ability of the UK to submit itself to the jurisdiction and follow the rulings of the Court of Justice. So if that is the position, and the UK sticks to its demands of having immigration controls and not being subject to the Court of Justice's jurisdiction, then it seems that if the UK wants to continue engaging in free trade without tariffs, then it's going to have to remain a member of the customs union. And if it's willing to remain a member of the customs union, then it would be able to negotiate something like the EEC Turkey Association Agreement, also known as the Ankara Agreement. And that agreement provides for the ability of limited free movement. And specifically, there's been an implementing decision number 1 of 1980 by the Association Council, which gave further implementing that provided for the further implementation of the Ankara Agreement. And under that decision, there's phased free movement of workers. So there is no, under that decision, there is no ability for Turkish nationals to automatically come to EU member states to seek work. National immigration law continues to apply, and they are subject to work authorization. So it's only once they've entered the member state and met the conditions for national immigration rules and obtained work permit, that then they start accumulating specific rights under the association agreement and specifically decision 180. And after 1 year of employment, they would get the right to renew their work permit with the same employer, but they don't have a right to change employer after the first year. After 3 years of employment, they get the right to change employer, but subject to national rules that give priority to the employment of nationals. And it's only after 4 years of employment in a member state that Turkish nationals get to enjoy free access to the labor market. They also get a right to equal treatment, but only as regards work conditions. So working time, conditions of pay, employment benefits as which are granted by employers, such as paid holidays, maternity leave, paternity leave, etc., etc. So they get to enjoy equal treatment, but only as regards working conditions. Social security is subject to specific rules that we will talk about in a minute. And family reunification, that is subject to national law. It is not provided, there's no right to family reunification as a matter of the EC-Turkey Association Agreement and specifically Decision 180. So family reunification, that would be subject to national law, and national law continues to apply to non-workers such as students and persons who might be claiming a right to self-sufficiency. If then the UK was to require immigration controls and specifically the imposition of work permits for EU citizens who come to the UK, then it could potentially sign up to something like the EEC-Turkey Association, which give rights over a period which would allow EU citizens to accumulate rights over a certain period of time of working in the UK. But they would have no right of free movement, no automatic right to obtain a work. They would be subject to work authorization, which would probably mean demonstrating that there is no qualified British national who's able to fulfill the same job description. And of course, over a period of time, EU citizens would be able to acquire rights, but it's only after 4 years that they would be free. They would have free access to the labour market, and that is something that the UK might be willing to accept as. In order to ensure, of course, that British citizens also have a right to go and work in other countries, which would be important given that some companies may decide to relocate from the UK to other member states to be able to continue trading within the single market. So obviously, the UK would see it to its advantage to accept some kind of limited free movement phased over time, even if the UK does not join the single market and agree to the free movement of persons under the European Economic Agreement. So that is a possible model to look at if the UK sticks to its desire to have controls placed on the ability of EU migrants to work in the UK. So before we look at social security, I'm going to see if there are any specific questions we have received from our experts who are following this webinar. I don't see that there are any specific questions, so therefore I will move on to the issue of social security and the implications of Brexit on social security rights. Some of the typical questions that Your Europe Advice is receiving are from people who are contemplating the effects of their rights following Brexit.
No emails received with questions.
Yes. Okay. Thank you. Yes, I just got confirmation from my colleague Susanna that we haven't received any questions either by email. So some of the typical questions that we get from UK citizens living in other member states or EU citizens residing in the UK who are worried about the implications of Brexit on their social security situation, and particularly people who are hoping to claim an old age pension, a state pension, following their retirement. And one of the questions is whether that we get is whether EU citizens can somehow transfer their contributions from the UK to their home country. And unfortunately, that is not presently possible under the EU Social Security Coordination rules, given that these rules provide that if you have contributed to the social security system of a specific country as a worker for over a year, then once you reach retirement age, you would be entitled to a state pension, provided you meet the eligibility conditions. You would be entitled to a state pension upon retirement from each country where you have worked. So, for example, a French citizen who's worked for, let's say, 15 years, who then comes to work in the UK and works there for 15 years. Upon retirement, he'll be able to get state pensions from both France and from the UK because he will have made minimum contributions in those systems. So we're getting questions from people who are worried about how Brexit might affect this situation, particularly when it comes to their pensions. And also we're getting questions about how this might affect healthcare rights, particularly, for example, for people who have retired and whose healthcare rights, whose healthcare expenses are borne by the country that pays their pension. And obviously, this affects the millions of UK citizens who live as retirees in Spain, in France, in Italy, in Germany, and who have reached retirement age, who are in receipt of a state pension from the UK authorities, and whose healthcare rights are paid for by the UK because the EU social security regulation provides that the country that has responsibility to meet healthcare expenses is the country that pays the pension. And if there's more than one pension that is paid by more than one member state, then it is the pension. Generally, it tends to be the country that pays the highest pension where the EU citizen contributed for the longest period of time. So the problem, of course, is following Brexit is we don't know what's going to happen to this social security regulation. It could be that the EU member states and the UK agree to protect acquired rights. So those people who already have moved to another member state would continue, for example, to be covered by the same legal instruments. That's one way that acquired rights could be protected. It could also be that there are specific transitional protections so that EU citizens get to continue benefiting from the regulation for a certain number of years, but after that, no longer. So there are different ways in which acquired rights could be protected, and of course that creates a problem in terms of trying to find a way now to explain what could happen. So let's look at the worst case scenario. Let's look at if there is no deal whatsoever on acquired rights. What would that mean? Well, firstly, it would mean that there would be no more right to exportability of benefits and pensions. It's EU law, the regulation 883/2004, that provides that If you are in receipt of a benefit or a pension and you move to another member state, you have a right to continue receiving that benefit and that pension. There are a few exceptions, of course, but the general rule is that you have a right to continue receiving that benefit and that pension wherever you may reside in the EU. And that, of course, in the event of the UK's withdrawal from the EU, in the event that there is no negotiated agreement that protects acquired rights, that regulation would cease to apply. So UK citizens who receive a UK pension in Spain, in France, would no longer have a guarantee as a matter of EU law that they would be able to continue receiving their pension. Now, what it means, if we compare that to, say, UK citizens living outside of the EU, say in Australia and New Zealand, it would mean in practice that they would keep on receiving their pension, but their pension would no longer be indexed. And the so-called triple lock mechanism that provides that UK pensions in the UK increase every year in line with inflation, in line with the cost of living, or by 2.5%, whichever is the greatest of those indicators, then their pensions are automatically indexed. And UK citizens who live in other European countries get to benefit from that right of indexation of their pensions because they have a right of equal treatment, and because the Social Security regulation provides that pensions are payable without reduction, without suspension, without modification, wherever they may reside in the EU. So, as a result of moving to as a result of the UK leaving the EU, in the event that there is no deal whatsoever, that there's no protection of acquired rights, then it would mean that UK citizens who receive a pension, a UK state pension in other member states, would basically have their pensions frozen at the amount that they get when the UK effectively leaves the EU. So that's for the situation of UK citizens, pensioners living in other member states. Also, another implication would be that there would be no obligation whatsoever for the UK government to continue paying healthcare rights, healthcare expenses, to bear healthcare expenses of those pensioners who reside in other member states who receive a UK state pension. So therefore, those people who reside in other member states who receive a UK state pension, who currently get to benefit from Form S1, which confirms that their healthcare expenses are paid by the UK, that guarantee would be done away with if as I said, the worst case scenario happens and there is no negotiated deal that protects acquired rights. So UK citizens would then have to either pay for their healthcare through private healthcare insurance, or they would, in certain circumstances, if the member state allows them, to pay into the national system. So, for example, pensioners in Belgium would have to pay whatever amount Belgian pensioners get to pay to get healthcare in Belgium. So that's what would happen for those who receive UK state pensions and who currently reside in other member states or intend to in the future. There would be no guarantee that they would receive a pension if they're EU citizens, and UK citizens would be able to receive the pension, but it would be frozen at the rate that they get when they retired, and their healthcare rights would no longer be met by the UK authorities. Of course, for other forms of benefits, they would no longer be exportable, and therefore anybody who might be getting some kind of a benefit other than the UK state pension because they've moved and reside in another member state, they would no longer be able to export UK benefits. So child benefits, which are paid to people who work in the UK but whose children live in other member states, that would no longer be possible. Also, when people claim benefits in the UK, any social security contributions that they have made in other countries would no longer be taken into account for determining whether they are eligible for those benefits. So this affects contributory, so-called contributory benefits. So contributory job seekers allowance for people who might have worked in another member state for a number of years. They come to the UK, they work for a certain period, and then they become unemployed. At present, when they claim job seekers allowance, the UK authorities must take into account not only how many years, months they have contributed to national insurance in the UK, but they must also take into account the social security contributions which that worker, that unemployed person, has made in other member states to determine how much job seekers allowance this person is able to get. And that is, of course, the principle, so-called principle of aggregation. That principle would no longer be in effect following the UK's withdrawal from the EU in the event there was no negotiated deal on acquired rights. Now, in terms of EU citizens living in the UK, of course, if the UK was to leave the EU and there was no acquired rights protection provided under the negotiated agreement following the triggering of Article 50 by the UK, in the event that there's no deal, then what would happen is that the regulation would cease to apply. So EU citizens who might be receiving benefits from another European country would no longer be able to receive those benefits in the UK. We have a case of the Court of Justice decided quite in the last 10 years, case 331 of 2006 called Chuck, which was to do with whether the EU rules apply to the payment of pensions to pensioners residing outside the EU. And the Court of Justice said no. The EU social security rules do not apply to people who live outside the EU, even if they might have been covered at some stage of their working lives by the social security rules of member states. So as a result, EU citizens who live in the UK, in the event the UK leaves the EU and there's no negotiated deal on acquired rights, those EU citizens no longer would benefit from the EU rules on the coordination of social security, and therefore they would no longer have a guarantee as a matter of EU law to continue receiving benefits in the UK. And so that would then be a matter for national law of the country that pays the benefits to determine whether they continue to receive those pensions or those benefits in the UK. Likewise, there would be no guarantee that if they are in receipt of benefits or a pension, that their healthcare costs would be met by the country that provides them a pension or benefit. So the EU social security rules would no longer apply, and in the absence that there's no special negotiated deal, then those rules would no longer apply, and it would be up to the national rules of the country that pays those benefits, those pensions, to determine whether those EU citizens can continue receiving those benefits or pensions, whether they can continue receiving them at the same indexation rates which applies as if they were living in a country that grants them that pension or benefit, and it's up to national law to determine whether they're able to continue receiving healthcare at the expense of the country that pays them the pension or the benefits. Now, the only thing that might save inverted commas, the situation of EU citizens is that the UK does have a number of separate bilateral agreements which are still in force between the UK and a number of different EU countries. I looked quickly to see on the internet to see what social security conventions, as they are called, exist between the UK and member states, and I came at least across 6. So it seems quite a few member states do. I found one for the Netherlands and the UK, one between Norway and the UK, one between Ireland and the UK, one between Malta and the UK, one between France and the UK, Sweden and the UK. So it seems a lot of member states have separate bilateral agreements on social security. Now, of course, their contents varies quite a bit, and it's not to say that just because there's a bilateral agreement that it will allow for the continuation of acquired rights. And of course, those bilateral agreements may be amended as a result of the UK leaving the EU. So we don't have any certainty that these agreements would survive in present form, but it's just to make you aware that just because the regulation is done away with, it doesn't mean that there will be an absolute gap, an absolute void in how the rules are regulated, because there are some social security conventions which the UK has signed up with the EU. Another thing to bear in mind is that if there was no deal on acquired rights, returning back to the situation of UK citizens in the EU, let's not forget that those UK citizens who live in other member states would still benefit from the social security coordination, but just not in respect of benefits or social security contributions that they might receive or might have made in the UK. So UK citizens who have worked, say, in other EU member states will still be covered by the social security rules, provided they remain in an EU member state and continue to live there following retirement. Then the social security regulations would apply to them in respect of benefits and pensions payable by other member states, not the UK, and in respect of contributions, social security contributions they might have made except in the UK. Also, one thing to bear in mind is Denmark does not apply this regulation. And it's a specific regulation, Regulation 1231 of 2010, which extended the benefit of Regulation 883 2004 to third country nationals who are living in other member states. At present, it does not apply to the UK, it does not apply to Denmark. In the event the UK was to leave the EU without negotiation deal on acquired rights in the field of social security, then this regulation would still benefit to some extent UK citizens who live in other member states, provided they stay there, provided, of course, they've made contributions, social security contributions in those states. But it would not, unfortunately, apply to their contributions or pensions in the UK. In terms of trying to identify what could be in a possible Brexit deal in the UK, that's extremely difficult to predict. Of course, we made some suggestions earlier about what potentially the UK and the EU could settle on in terms of some kind of agreement, limited agreement on free movement of people. I identified the EEC-Turkey Association agreement as a possible model if the UK were to stick to its demands of controlling the ability of EU migrants to work in the UK and not to be subject to the Court of Justice's jurisdiction. There's, of course, that agreement provides maybe some kind of view into the future of what could be negotiated on social security, but basically that would require a specific agreement, of course, between the EU member states and the UK. The agreement would have to be probably, given that it would regulate the future relationships between the future relationship between the UK and the EU, would constitute a treaty and would have to probably be agreed by all member states. It could be that, again, if the EEC-Turkey association agreement is followed, that would provide that that would provide, if it's replicated for the situation of UK citizens in the EU, it would provide for them to be able to continue to be governed by the social security rules. And it could also provide that, provided there's a specific agreement to that effect, it could provide for social security contributions made in the UK also to be taken into account by EU social security institutions in the future. It would also allow for benefits and pensions to be exported. But as I said, this really depends on the substance, the details of the negotiation between the UK and the EU. But if, as I said, the UK was to stick to its demands on immigration controls and not being subject to the jurisdiction of the Court of Justice, then it could be that the EEC-Turkey Association Agreement becomes a likely model, and there it could provide for acquired rights on social security rules. So I hope this has been a useful presentation on the implications of Brexit. We've looked at, hypothetically, what could be the outcome in the event the UK leaves the EU, looking at the worst case scenario in the event the UK leaves the EU and there's no special deal, but also what could be a possibility given the UK's demands for immigration control and the end of the jurisdiction of the Court of Justice. So thank you very much for attending our first webinar, the first webinar organized by Your Europe Advice, and we hope to see you next time. Thank you all. Goodbye.